It's 57699, matter of Alfred L. Isassi, petitioner. You ready to proceed?
Yes, sir.
And respondent?
Yes, Your Honor. We did have a matter that we'd asked you to take up specifically before on our motion.
I've looked at it, and a couple of responses that Mr. West. Number one, it appeared to me to be in large part another way of addressing the exhibits that we talked about on Monday, and I'd already ruled on that. And second, I did not see how it was feasible to comply with your request for me to look at it, no one else. So I did not, and so the motion is denied, obviously subject to your making objections as we go along.
And that's what I'll do, is if I feel like there's improper argument, I'll...
Absolutely.
All right.
Absolutely. I just didn't see another way to handle
I
it.
understand.
All right. Thank you very much.
Yes, sir.
You ready to proceed?
Yes, sir.
Okay. Thank you.
Board, I'm Dean Schaefer here for the commission. We're here on a compulsory discipline case. The respondent, Mr. Isassi, was convicted of tampering with a governmental document. It was a jury conviction, state jail felony. The elements of the crime, and this is under Texas Penal Code 37.10A2. Elements are to make, use a document with knowledge of its falsity.
Pardon me, and I apologize for
No, go
interrupting.
ahead.
It's the very nature of this kind of argument, as I had informed you during our conference, that we are not here to argue that the conviction occurred, and therefore my objection would be relevance to going into the elements of that conviction. We will be offering Mr. Isassi's testimony on the Philippoff standards, but we will not go behind that conviction, so I would say it would be irrelevant.
Are you objecting to or attempting to show that it is not a serious or intentional crime?
No, we're not. We're simply, we're not even here under the Mercier case. We're here saying that the conviction exists. We believe under 805 and 806 you have the ability to decide whether to suspend rather than disbar, and we want to offer testimony concerning that suspension and the effect of that. So that's why I would say any argument or testimony to the contrary is really not relevant.
Well, Mr. Schaefer.
Am I correct in understanding you would agree to every issue that has been made by the allegation by the petitioner, except the discretion whether 805 or 806 ought to be employed and what evidence would be applicable to that discretion?
Yes, Mr. McKellar.
In that case, I wonder if the petitioner could offer the exhibits without needing to narrate the exhibits.
I agree. I don't, unless there's something you think is additional, I don't see any need to go into any long proof. I think we're here on one issue, and let's hear that one. I think that's the right way to approach this.
So, okay. So you're going to skip opening?
No, I'll be happy to give an opening, just a brief opening.
Well, if you just want to put the predicate documents in, or if those aren't even, well, I think it would.
I think the issue is that this is opening, not presentation.
Okay.
And if I might add, Mr. Black, in that opening, so that the full board is aware, we have had a full, robust meeting over exhibits, and the exhibits you have before you are pre-admitted. We've all agreed to those exhibits on both sides, and we had a nice hearing with your chair concerning some exhibits that are not coming before the board, and we're not going to attempt to offer them. So I was simply objecting in opening to go into elements of a crime when that's really not an issue. That was my objection.
Okay.
Thank you.
Do you have anything else you want to offer in your opening? And go ahead, so we'll get back on track here.
Yes, sir. I do think the elements are relevant for the court to consider in deciding whether to exercise discretion. The type of crime, the situation that the lawyer was in, past history with this type of crime. Those are all relevant to whether the board chooses to exercise discretion. This may be a case where the Philipov standards of mitigation or aggravation are not really the issue. The issue is more, do we have a case where the board doesn't need to exercise discretion to get to those factors? So I can bring it up at a later time. Board's aware of the starting point with a crime like this, that the starting point is disbarment. We consider the nature of the crime as it bears on the attorney's moral fitness to continue in the practice of law. We have additional restrictions on what can be heard today. There are no appeal points because the respondent has dismissed his appeal, and no collateral attack. And one other issue that I expect will come up today has to do with judicial clemency. And as the board is aware, there are recent precedents from this board that effectively hold that compulsory discipline is not precluded by judicial clemency. And that's what we have for our argument.
Okay, thank you very much.
Thank you.
Mr. West?
Thank you. As Mr. McKetta said, we really just are zeroing in on this one question. And as I mentioned in my objection, we're not asking for revisiting the Mercier case. We're here saying that we believe after you hear the evidence that I'll present, which will be from my client, I'll put him on the stand, that it will be compelling to have you consider that suspension is the proper remedy, and that because clemency was granted, that AMET applies in this instance, and he is actually already, you will learn that he has actually served many more days of suspension than he actually should have, in terms of the fact that we should have had a hearing several months ago and couldn't because of our court reporter situation. But he agreed to a continuation of the suspension, and you'll hear that testimony as well. So our goal will be to show that suspension is merited, and that under the AMET standard, once that judgment was set aside by the judge, that you should be left with the decision to dismiss this matter. We feel that there's really already been a review, a Philipov review by the reviewing courts in this matter, and we'll bring that to your attention by looking at Code of Criminal Procedure under 12.44a, the review that was made then, and then the clemency review that reviewed some of these same standards that we look at in Philipov. So that's where we plan to go.
Thank you very much.
For evidence, the commission has brought a series of exhibits. You have notebooks before you. Everything in that notebook has been pre-admitted. And so to open the evidence, I'd like to go through those exhibits with the board.
For the record, let's just, petitioner's exhibits 1, 2, 3, 4, 5, 6, 9, 10, 12, and 13 are all agreed upon and pre-admitted. Is that correct?
That is correct.
Then they are admitted. Go ahead.
Exhibit 1 is the indictment by which Mr. Isassi was charged with tampering with a governmental record. The indictment reads that the defendant on or about February 17, 2015, with the intent to defraud or harm another, namely the Cleburne County Attorney. The defendant did intentionally and knowingly make or present or use a record or document, to wit, a motion in order to dismiss a case with a forged signature, and with knowledge of its falsity and with intent that it be taken as a genuine governmental record. That indictment issued June 18, 2014. Turn to Exhibit 2. This is the judgment of conviction by jury. This is in cause number 15-CRF-0182, Cleburne County Court. Cleburne District Court. The jury did convict the defendant of tampering with a governmental record, state jail felony, and the respondent was sentenced to 2 years confinement at a state jail facility. The sentence was suspended for community supervision for a period of 4 years. At Exhibit 3, sometime after that judgment issued, Mr. Isassi did come back and receive an amended judgment of conviction by jury. There was an exchange at that point where Mr. Isassi agreed to drop his appeal in exchange for getting this revised judgment. Under this judgment, the punishment fell to 1 year confinement with 2 years community supervision. Tab 4, we have provided the affidavit of Rebecca Stevens to firm up that Mr. Isassi is who we say he is. We've also provided at Exhibit 5 the statement of the clerk of the court about Mr. Isassi's previous history for discipline. There was a brief administrative suspension back in 2002, and he is not currently authorized to practice. That's as a result of an agreed suspension after the matter came to the board. At tab 6, there is prior disciplinary history. It had to do with, as set out in the agreed judgment of probated suspension, it had to do with Mr. Isassi communicating with someone he knew to be represented by counsel. And this occurred at a time when Mr. Isassi was an elected judge in Cleburne County. At tab 9, there's a criminal history, a prior criminal history. This is the judgment of conviction by jury. Judgment was entered back in 2011. The crime was improper influence. The events at issue with this conviction occurred while Mr. Isassi was the county attorney for Cleburne County. The sentence was confinement, 1 year in a county jail, suspended for community supervision for 6 months. That conviction was appealed at Exhibit 10. We brought the opinion by the Court of Criminal Appeals. That appeal did go to the highest criminal court in the state, and the opinion addresses at length the intent element of that crime. Exhibit 12, we brought to you the dismissal order confirming that for the crime that brings us here today, the one that triggered compulsory, Mr. Isassi has dropped that appeal. So there are no appeal points. That case is done. We have also brought at Exhibit 13 a transcript from the clemency hearing. And within the transcript, there are things that I suppose both sides would bring to your attention. I do bring attention to page 7 wherein the hearing, the judge who did grant clemency made the comment, this is at line 10, page 7. Actually, you know, it doesn't erase the fact that he was convicted. On the same page, the court asks, you can expunge the record, can't you? And Mr. Palacios, the attorney for Mr. Isassi, replied, Judge, this case can never be expunged. Those are the exhibits we have before the board.
All right. Do you have anything else you want to offer at this time, Mr. Schaefer?
That's it this time.
Thank you very much. Mr.
Thank
West?
you. We would like to first call Alfred Isassi.
Mr. Isassi, take a seat up here and have the court reporter swear you in, please.
It'd be better, all right if I sat at the desk.
Whatever you're most comfortable,
Thank you,
as
Mr.
long as everybody can hear you.
I will try to make my voice loud and clear. Mr. Isassi, let me remind you to keep your voice up because the acoustics in this room are not real well, so I may have to remind you as you go along.
Yes, sir.
Is he sworn in?
Yes.
Thank you. Mr. Isassi, describe for the board who is with you here today.
Well, today, both my parents, my father, Robert Isassi, my mother, Dahlia Isassi, my lovely wife, Tina Isassi, and my 7-year-old son. Also had the honor and privilege of my brother driving up from Corpus Christi, Robert Isassi, and a good friend and also an attorney, Eric Flores, is also here with me this afternoon.
How long have you been married?
This December will be 10 years. It's 9 years. So December the 1st will be our 10-year anniversary.
It's a good date to remember.
It is.
Where were you born?
I was born in Little Rock Air Force Base. My dad was an Air Force serviceman at the time. I was born in Little Rock, Arkansas.
And what did your parents do for a living?
My dad's a veteran. He worked for civil service for NAS Corpus Christi as a civil servant for the Navy. And my mom was a school clerk or school secretary for the Kingsville Independent School District where I grew up.
And you identified one sibling. Do you have other siblings?
I do have one more sibling. He's also a serviceman. He's active duty Air Force, and he's now stationed in Grand Forks, North Dakota.
And where did you attend college?
In Kingsville, Texas A&M, also known as A&I, A&M Kingsville.
What did you study there?
I have a business background, business finance.
Did your mom and dad go to college? Did you just follow in the tradition of college in your family?
They didn't graduate college. I know my dad has some associate's degree from Georgia military, but neither of them completed a 4-year degree.
Did you go straight to law school after graduating?
No, sir. I was 3 years after I graduated. I went to law school.
And did you do anything in between? Did you teach or something like that?
I did. I worked for the school district. I taught the computer lab, and I worked for the county as an office manager. And having a finance degree, I was a loan officer for beneficial finance before going to law school.
When did you graduate from law school?
December of 1998.
And what did you do after employment after law school?
My first job, I got kind of backwards. I became an assistant district attorney for the 105th, prosecuting felonies in my home county, Clayburgh, Nueces, and Kennedy County. It's a 3-county jurisdiction in South Texas.
And then did you progress along? What else did you do?
Well, again, being backwards, the county attorney position paid more, and I became the assistant county attorney for Clayburgh County there afterwards.
And then did you run for election?
I did. I was honored enough to win the seat for county attorney for Clayburgh County in my home county.
And how long did you hold that?
1 term, 4 years.
And then what did you do after that?
Private practice.
And how long were you in private practice?
3.5 years.
And then were you elected to the bench?
I was elected. They had the honor of serving as the county court at law judge for Clayburgh County.
And you served in that position until when?
Till I was indicted I believe I was indicted I know that the incident happened in February. I believe I was indicted I served 6 months in June of 1996.
Okay. Now, do you drink or use drugs?
No, sir.
And you stepped off the bench in September of 2015?
That's correct. The date the indictment was handed, I stepped down from the bench.
Have you worked as an attorney since the date of your conviction?
No.
Since you haven't been practicing law, how have you been spending your time?
Stay-at-home dad, Mr. Mom,
What do you take care of at home?
excuse me, my son, the laundry, the honeydews, cut the grass, pick him up to and from school. Been tough financially.
Is your son in Scouts?
He is. I'm the adult leader for the scout troop. Again, I have a lot of free time on my hands, so I'm the t-ball coach, the scout leader. I chaperone his school events when technically he's supposed to be on a field trip today, but he's here with me today, and I spend a lot of time at that school. They know me on a first name basis, and again, without practicing law, I've just been doing which is honored, being a dad.
I suppose this will count as a field trip for your time today.
I told him that after we were coming back from lunch.
Okay. Do the organizations you volunteer with know about your conviction?
They do.
Why?
I live in a small community. Claybrook County is a county of 50,000. When the county court at law judge gets in trouble, it's front page news.
Are you involved in your community in other ways?
I am. I attend church regularly with my wife. Like I said, I volunteer at my son's school. I still get asked to serve on certain things, but at this time, I just don't do it. I volunteer. I'm still a member of the Rotary and the Lions Club, but not active. I'm like an inactive member of those organizations.
If the board were to grant your request to dismiss the bar's petition or the Chief Disciplinary Counsel's petition, what would you plan to do?
Well, I've been practicing since I got licensed, other than this suspension. I want to go back into general practice. I mean, I'm a South Texas lawyer. People think Keensville's the Valley. We're not the Valley. We're south of Corpus Christi, and I want to open up a general practice like I did prior to taking the bench.
Be like, what would you do?
I'd handle misdemeanor cases, divorces, and then again get back into the felony criminal work. We call it general practice there in South Texas. And not PI stuff I don't do, and don't do any corporate work, because again, in South Texas, those cases don't really exist.
Tell the board why you want to return to the practice of the law.
It's what I've known. I was, I believe, 25 when I got licensed in 1999. Actually, it was May, because I know that was my month of my birthday. And I liked helping people. I mean, that's why I served as a prosecutor. I started my career as a prosecutor, got the honor to wear the robe, granted short time for 6 months, and again, great embarrassment to me and my family. Excuse me. I just want to help the people that need help.
What crime were you convicted of?
The crime was tampering with a government record.
And what were you accused of doing? And I'm not asking you to get in behind that conviction,
Yes.
just so that they know you understand what it was.
I was accused of forging the prosecutor's signature on a dismissal form.
And you never pled guilty to that, did you?
I never pled guilty to that.
What was your punishment?
It was what we call 1244 of the Penal Code. It was reduced to a misdemeanor. Initially, it was a state jail felony. The judge, at the end of the day, convicted me of the state jail felony, sentenced me to 2 years state jail, suspended that, and placed me on 4 years of community supervision or probation.
And I think in some community hours, like a hefty amount.
Correct. And I think it was over the requirement. He initially put 100 hours of community service.
And then it was 800 hours, I believe.
Yes. It was 800 hours initially, and then the judge realized he couldn't do that many hours. Again, this was at the end of the business day, and it was a visiting judge.
That's all right. You don't need to get into that. Why, or was that punishment reduced? Not why, just was that punishment?
It was reduced.
And that was the application of the 1244A, that's what you're saying?
That's correct.
And do you know generally what 1244A is?
As a criminal prosecutor, as a criminal defense lawyer, it's a statute in the Penal Code that allows a state jail felony to be reduced to a misdemeanor.
And was your punishment later terminated?
Yes.
All right. And let me pause just a minute, Chairman Kettner, and just say that the stack of documents that you have in front of you, not in a notebook, are the documents that we have agreed are pre-admitted. They would be exhibits 1 through 8. And for your tactical appreciation, when we were comparing exhibits, petitioners 1, 2, and 3, and respondents 1, 2, and 3 are identical. Respondents 4 and 5 are something that you don't have. And I can get into that in the in my communication with, or you don't have in petitioner's exhibit. You just have it in respondent's exhibit. So I thought this would be a good time to mention that.
Thank you.
But I believe they've already been offered and admitted, but I will make that formal request.
Okay, well, let's just do that so there's no dispute.
It would be respondents 1 through 8.
Mr. Schaefer, any objection to respondents 1 through 8 being admitted in evidence?
No, sir.
Okay, they're admitted.
And thank you. And then the other documents that you have behind those respondents exhibit will be the Code of Criminal Procedure 1244A,
Right.
and Chapter 42 dealing with early termination, and then the 3 cases that I will reference, of course, the Filippov case, the Ament case, and the Cuellar case.
Thank you very much.
All right. And I'd asked you, was your punishment later terminated?
It was, yes, early termination is what it's
And
called.
how was it terminated? Was it, do you know the term?
Yes, we filed a motion for early termination with a request for judicial clemency.
And what's your understanding of judicial clemency?
My understanding of judicial clemency is again, the reading of the code, of the criminal code of procedure is, there is no disability or penalties, and all rights of mine are returned, voting rights, all other legal rights. I believe
You got them all back?
I got them all back. Yes.
Okay. Now, you heard the CDC attorney reference that clemency hearing. Do you remember that hearing?
Vividly.
And on page 8, and that would be P13, that is petitioner 13. On page 8 of that transcript, do you remember the court stating, and again, that's at line 16, I will state, I think he has shown, based on probation, he's done a good job. I think he's back. I think he will not commit another stupid mistake like this again, or any type of mistake that involves any type of illegality. And I think he deserves a chance. That's my opinion. So I'm going to grant that. Okay. Do you remember when he said that?
I do, and I remember saying stuff off the record he told me.
Well, I'm not going to ask you that.
Yes, sir.
And after that clemency hearing, then you understood at that point that terminated your criminal issue. Is that correct?
That is correct.
Okay. Have you held yourself out as an attorney since you've been suspended?
No, sir.
What about if people ask for your help? What do you say?
That I'm unable to help them.
Have you performed any legal services for others or given any, even free legal advice to anyone?
No, other than call someone else.
Have you accepted any fee, directly or indirectly, for legal services not completed before the date of that order?
No, sir.
Have you appeared as counsel in any proceeding in any Texas court or before any Texas administrative body as an attorney?
No, sir.
Have you used your name in any manner in conjunction with the words attorney, counselor, or lawyer?
No, sir.
Did you have any clients as of the date of that order?
No, sir.
Because you were a sitting judge?
I was sitting judge, yes, sir.
And then you stopped practicing after that happened?
Yes, when I became elected and took the bench, I had no active cases.
How much of the probation did you serve? Was it almost 12 months?
It was close to the 12 months. I know it was 11 months and some change.
And how many community service hours did you actually do?
I did over the above requirements. Over the 85, I probably did 100
And I believe at Respondents Exhibit 7 is a compilation of those hours. Is that correct?
I believe so.
All right. And that's accurate as far as you know.
Yes, sir.
All right. Did you pay your fine and court costs?
I did.
Did you check in with your probation officer as required?
Yes, sir.
What have you done to better yourself since your conviction?
Oh, with my wife being religious, I've read some self-help books.
What does your wife do, by the way?
My wife's a licensed social worker for a hospital.
Okay. So you've read some self-help books. What else?
Attended church as often as we can regularly if it doesn't conflict with scouts.
What church do you go to?
We're going to Coastal Bend Fellowship Church.
Is that a Bible church?
It is a Bible-based Baptist church.
Okay. What about, have you reflected on the practice of the law?
Every day.
What about have you had any bouts with, just blaming yourself?
I do.
How do you handle that?
Pray, God, and the strong support of my family.
Aside from the underlying conviction, has your truthfulness as a lawyer been called into question as far as you know?
No.
Even though you pled not guilty, are there things you could have done that you now look back on to have avoided being put in that situation?
Yes.
And in reflecting on those things, do you now know that there were things you could have done to prevent where you sit today?
Very much so.
Are you sorry for that?
Deeply. Deep.
You've been disciplined by the bar previously. You heard the CDC lawyer talk about that. In 2002, that was his exhibit number E6, I believe. No, I don't know what number it is. Anyway, in 2002, you were suspended for a couple of weeks, weren't you?
That took me as a surprise. Yes, I did. I wasn't aware of that till recently or until this case came about. Yes, sir.
What happened? Why?
They said I missed the date to pay my bar dues, and I think at that time I was the county attorney, and the county was going to pay for it. And I think there was a 2-week lapse in that payment being received by the bar. But that was news to me.
Now, at the same time your conviction issues were occurring, you also had an agreed suspension for something that you did that caused you to serve a 4-month suspension, right?
That's correct.
And did you learn from that episode?
I did.
You talked to someone that you knew was represented by counsel, is that correct?
That's correct.
And when you recognized the problem, you agreed with the suspension, did you not?
I did.
And you served that suspension,
Faithfully.
okay? What have you learned about good intentions?
While you have good intentions in helping people, clients or ex-clients, or that good intentions sometimes can conflict with the rules of disciplinary procedure.
Your Honor, I'm going to object to that because I think he is starting to go behind the conviction.
Overruled, go ahead.
I've learned that good intentions is sometimes the saying is, no good deed goes unpunished. And I've learned that while good intentions, the rules are the disciplinary rules and should be followed to a T. And I've learned that the hard way.
You know those disciplinary rules better than ever, don't you?
Unfortunately, but I think now fortunately, yes, I do.
Okay. Now, you also heard reference to the criminal conduct back when you were county attorney in 2008. Is that right?
That's correct.
And those events happened, I think, in 2005, didn't they?
Yes, sir.
Okay. Now, you were convicted on those 2 misdemeanor counts. Is that correct?
I was.
And were you disciplined by the bar for those?
No, sir.
And those were misdemeanor counts. They were neither intentional or serious crimes, were they?
Not to my knowledge, no.
How long has it been since you've actually practiced law? Number of days?
The day I stepped down from the bench in June of 2015
To the current?
to current, I believe it's 582 days if my calculations are correct.
That would be counting today?
That would be counting today.
Okay. The grievance-related suspension lasted 120 days, is that right? From
That is correct, Your Honor. Yes, sir.
February 1 of 2016 to May 31 of 2016?
4 months, yes, sir, 120
Right.
days.
And your agreed suspension in this matter began on July 26 of 2016 and continues to this day, correct?
That is correct.
And that's 277 days total, is that correct?
Yes, sir.
And your self-imposed suspension was for a total of 184 days from September 23rd, 2015 through January 31st, 2016. That amounted to 130 days, is that right?
That is correct. We came here in January, and then we added, I agreed to the suspension continuing.
And then between the June 1st and the July 25th agreement not to practice, that was another 54 days, correct?
That is correct.
So your total suspension agreed and self-imposed, agreed with this body and with the bar and self-imposed, totals 461 days through the day, is that correct?
Over a year, yes, sir.
And the number of days that have passed from the effective date your punish began to the date of the clemency order is what? About 373 days, something like that?
That's correct.
Okay? So you've actually served, though, a combined agreed suspension yourself with this board and with the bar, and your self-imposed suspension for a total of 461 days to the current date. Is that correct?
That is correct.
In our exhibits at Exhibit 6, there is an affidavit of character from Sam Fugate. Is that the way you say his name?
That is the way you say his name.
And who is he?
I guess we call him the dean of our bar. He's currently the mayor of Kingsville, prominent defense lawyer in our community.
And how does he know?
We had attended church together at Methodist Church. His wife was my son's kindergarten teacher. He's known my family for quite some number of years, and he's a friend of mine.
And then Exhibit 7, you recall I referred you to that earlier. That's those agencies that have tabulated your community service hours, correct?
That's correct.
And then exhibit number 8 is Veronica, is it Gary?
Garza.
Garza, I apologize. Garza. And who is she?
She's an attorney in the Corpus Christi area, colleague of mine. We office shared one time together when I was in private practice.
And so why does she know you even today? If she was once in private practice with you, have you maintained a friendship?
We've maintained a friendship, or one of her child and my child share a birth date, and we're, again, the legal community in Corpus and Kingsville is a small legal community. We all pretty much know each other.
Do you respect both Mr. Fugate and Ms. Garza?
Yes, sir.
Do you believe that you hold their opinions about you appropriately concerning what they know about you and what you've done?
They do.
I'll pass the witness.
Mr. Isassi, you testified that you never pled guilty to the tampering charge, but you don't dispute what the jury found.
No, I did.
And you understand the jury did find that you had intent in committing that felony. You understand that?
I don't understand that.
You were a judge?
I was.
Your Honor, this is aimed at going behind the conviction, and we have agreed, coming here today, and stated that this is not our purpose to go behind that conviction.
Pardon me, let me ask the question. Are you taking the position that it is not a pertinent consideration to know the seriousness and extent of the circumstances when determining whether to exercise discretion under 805 or 806?
Mr. McKetta, if this board wants to ask questions or have counsel ask questions concerning it, then...
No. I didn't ask, what if we want to do something? I'm saying, are you taking the view that the board should not consider?
No.
All right.
I'm just simply saying that the question, I'm objecting to the question that was made because I believe it was aimed at going behind the conviction rather than to discuss the seriousness of the offense. And
Well,
it doesn't relate to a Philipov standard.
I'm going to overrule the objection only because you'd asked him if he had pled guilty, and I do think it's
I
appropriate
understand.
for to inquire about that, but keep it short if you would.
Thank you.
Now, you also testified that with the prior conviction, you didn't think that was an intentional crime.
No, I don't believe I said that.
You didn't hear anybody tell you it was intentional?
Who?
Your Honor, if I could, again, I object to the kind of question because it is misleading in that we have a specific definition that we deal with in the grievance parlance called an intentional crime, yet the crime that he's referring to may have had an intent element, but I want to make sure that it's not a trick question.
I'm sure he didn't mean it as a trick question, but again, you asked him about it, and I think it's fair for him to follow up on it, and you can draw back on your redirect.
Yes, Your Honor.
Let me just briefly respond to these objections.
I don't think you need to. I've overruled it, so you can go ahead.
So, sitting here today, you acknowledge the first conviction did involve an intent. Fine.
Yes, sir.
And the conviction that brings us here today, that too involved an intent element.
Yes, sir.
The first conviction was a misdemeanor, right?
Correct.
That was while you were county attorney?
Yes, sir.
And then some years later, you were a judge and convicted of a felony, right?
Yes, sir.
There was also this prior disciplinary history. Talk about that for a minute. As far as just the general background of what that grievance involved, is it fair to say that you had represented someone before you took the bench, represented a husband in a divorce case? Is that right?
Yes, one of our deputy sheriffs, yes, sir.
And what happened about that divorce case and things that you did after you took the bench, that was the subject of the grievance, correct?
Yes, sir.
And is it true that after you took the bench, no longer representing the husband in that divorce, you picked up the phone and called the wife, knowing that she was represented by counsel?
Did not know that I was told by my former client that she no longer had counsel, is what I understood. But yes, I did make that phone call.
And for the time you were counsel, you knew that she had a lawyer.
Yes.
And you made the call intentionally.
Yes, sir.
So, would it be fair to say that in each of these instances, intentional act that was found to be improper influence while you were county attorney, intentional act of calling someone known to be represented by counsel, intentional act of tampering with a governmental record, is it fair to say that from all those things, it's important that you learn something?
I've learned deeply, yes, sir, I've learned many things from these acts and problems that I've had.
And that's the whole point of discipline, isn't it?
I believe so.
Discipline comes from a word that is the same word that disciple comes from.
Yes.
Now, as far as the conviction that brings us here today, You don't quarrel with the punishment that was originally assigned, correct?
I believe we did. We filed a motion to reconsider the punishment, and that's how it got reduced to a misdemeanor. So
But-
the answer to your question, I did quarrel with it.
But you don't anymore, right?
With the subsequent, no, sir.
So as we sit here today, you don't have a complaint about what the jury did, right?
I don't know how to answer that, because I've always maintained my not guiltiness. I've maintained my innocence. However, the jury found me guilty, and I'll accept that. But I don't know how to answer your question. I do accept what the jury said. Do I agree with it? No.
Your Honor, I think he is starting to testify behind the judge.
I disagree with that. Go on.
Now, in terms of what they did find, it had to do with forging the name of a county attorney on a dismissal document, right?
That's part of the allegation, I believe so, yes.
You were accused of, for a former client of yours, signing the county attorney's name on a motion to dismiss a charge that was brought against her, correct?
I believe so, yes.
Your Honor, I believe these questions are aimed at badgering my client in terms of, I don't see that this relates to a Philipov standard. I would object to it because I think it's.
Where are you going, Mr. Schaefer?
We're not just concerned with Philipov. The nature of the offense, running a Duncan case, that's something the board is supposed to consider. There is law written in, well, it's a concurrence by Justice Owen and Enid.
Well, I think the board understands the underlying conviction. We've read the materials and the documents and things like that, and while I'm not trying to tell you what to do, I think it would be better to see if the board has any questions after you have finished. So I don't know that I don't agree that you're badgering the witness, but I'd like you to move on.
I'll pass the witness.
Okay.
Can I ask a question?
Well, let me just see if Mr.
Sure.
West has it. Let him finish, and then we'll open up to the board.
I don't,
Do you have any further questions, or I just don't want to interrupt your flow here.
thank you. I'll pass the witness.
Okay. Ms. Kinzer?
Sir, I'm really struggling with your testimony, so I want to make sure I understand. I've read what has been provided to us about what we should be relying on to make this decision, and I understand it's very important to you. I guess I'm struggling with, do you understand that what you have been convicted of was wrong,
Very much so.
and that you bear the sole responsibility for your actions?
I take responsibility for what I did, and again, yes, ma'am.
So when you say, I accept it, but I don't agree with it,
Yeah,
maybe what I'm saying is, are you truly remorseful? Or are you just here to say, please don't do this to me?
no, I'm very remorseful. I'm remorseful every morning I wake up, and I don't get to call myself a lawyer. I'm remorseful for my actions that got me to this position. I'm remorseful for many things that, while I'm here, I'm remorseful for the other act that happened in 2005. Yes, ma'am, I'm remorseful deeply.
Thank you.
Maybe you could help me. Could you tell me if we look at the Philipov factors about whether you accept responsibility for past actions, rather than say, I accept the judge, would you tell us what you accept responsibility for?
Talking to my former client, again, I believe that was, not to get to rehear the whole thing, I thought her cases were taken care of. Because again, I was her lawyer, and it's a small community, and I know my clients, and so to answer your question is, I should have done it a little bit different, or recused myself from that case as a former client, but I should have done many things differently in this case.
Okay, so you accept responsibility. So we're talking about Ms. Cornell's case?
Yeah, that's correct.
Related to the trial, we don't know if he testified or not, and I had a similar concern. I'm having a hard time saying whether you accept responsibility for the actions you did related to what happened to her case and the county attorney, or I accept what the jury's verdict is. when you talk about mistakes you made, what are the mistakes? One, you should have excused yourself. What other mistakes are you referring to that you take responsibility for?
Probably did it in a little bit more formal setting instead of the county attorney's office. I mean, we're a small rural county. Should have probably done a hearing on it a little bit more different and appointed Ms. Cornell a different counsel to resolve these issues. Those things I should have done different. And I don't know if I answered your question, Mr. Gonzalez.
So she had a lawyer there, right?
No, that's where she was there to either get court-appointed counsel after the fact. I believe either myself or the JP visiting judge appointed her lawyer. I don't recall at that point. I don't recall, Mr. Gonzalez, if she did or didn't. But I know ultimately she finally did have another lawyer.
And so one of the issues that I think you don't take responsibility for, you dispute, is whether or not you actually forged a signature of the county attorney. So to this day, the answer is still no, I did not.
I know in my heart I did not forge anybody's signature on that document. And again, I know that, and that's the truth. And again, whether the jury found me guilty, and I'll accept the jury's finding of guilt, and I accept the consequences of what happened to me. But no, I did not forge that document.
Well, does that mean your hand wasn't on the pen, or you had permission? What does that mean?
That means I filled in we use a form. I filled in certain portions of it, gave it to Ms. Talib, and asked her if she would sign it. Would she agree to this dismissal of this case? So I did not sign her signature on the signature line in these form-driven criminal cases. But I do filled in the rest of the pertinent part of the document.
I'm confused. In 2005, you were convicted of 2 different occasions of improper influence with the intent to cause consideration of a criminal judicial proceeding in unlawful ways. 2 counts, is that right, in 2005?
Yes, sir.
And are you saying that in 2000, when was this event? February 2015, you went as a judge to the county attorney's office to try to get her to sign a form for dismissal of somebody you had represented as a client for years?
I wouldn't couch it that way, but that could
Why
be.
did you go to her office in your version of the events?
Our courtroom is right in front of our office.
Why did you go to the prosecutor to ask for dismissal of somebody who had been your client for years?
That's the mistake I've made. I wish it
Is
not.
that not what you did in 2005, except in different hats? As an official entrusted for the public good, you went to other officials to try to achieve things in improper fashion.
I believe. I don't know. Yes, but I believe it could be seen that way. Yes.
Taylor. Let me clear something up that I think you've been given bad information about. 1244A is not a reduction to a misdemeanor.
No, I agree.
It allows a judge, for somebody that's been convicted of a state jail felony, to give them misdemeanor punishment. But you are still convicted of a state jail felony. Okay, do you understand that difference? And if you look at B, then that's the other version of it. That allows them to prosecute the case as a Class A misdemeanor, so which actually reduces the case to a lesser offense. But as we sit here now, you have been convicted, even though your judgment was amended. That's still a conviction for a state jail felony. You understand that?
I do.
Okay.
And I understand.
Because you stated it differently on the record earlier.
I-
And you know, this is a tricky little statute. But it's these kind of statutes that, especially if you're a judge or a county attorney, that you need to understand the difference between those two things. It's not like you can just spout off and go, well, I got convicted of a felony, but really they reduced it to a misdemeanor. And so that's all I'm convicted of now. That's kind of what you said to us earlier. And that's not the case here. You understand that? You
I
understand
do, and I believe I'm with you on that, reading that law, and I agree with you. The felony is still there. However, the punishment is the misdemeanor punishment.
You
Yes.
got misdemeanor punishment, but you're still convicted of a state jail felony.
Correct. And
Okay.
I understand that, and I probably did misspeak when I said that. I didn't clarify, yes, the punishment is a state jail felony. However, the conviction's a felony, the punishment's a misdemeanor.
That's
Yes,
right.
yeah. And I agree with that.
You got it right.
That's what's telling.
All right, now let me ask you something else, Mr. Isassi. Do you believe that the Bar Association and this board and evidentiary panels and people that dish out discipline to lawyers should hold judges and elected officials to a little bit higher standard?
I believe everyone should be treated fairly. Yeah, the answer is, and perhaps yes.
Well, the public's put, as Mr. McKetta said, the public's put their trust in you when they voted for you as an elected official of Clayburgh County, both times. And do you believe that that trust should be honored?
Yes, sir.
And do you believe that perhaps an elected official like yourself should be held a little bit to a higher standard? They look up to you. They look up to you. They voted for you. They expect you to trust you.
I agree.
You agree with that?
I do agree with that.
And so this kind of offense, these kind of offenses that you're charged with, both times when you held the public trust, as Mr. McKetta said, and were looked up to by your people, by the people that voted for you, your constituents, are the kind of offenses that they don't want to see. People don't want to see their public officials commit. Would you agree with that?
I would.
Okay. And is that part of your remorse here today?
Very much so.
And I think what Ms. Kinzer was saying, and what we're all trying to get at is, you're a politician and you're probably gifted. Because, you don't get votes and you don't win elections unless you're gifted. And what we don't want is somebody coming up here and telling us they're remorseful, because they're gifted and able to look us in the eye and tell us those things and not feel it and not believe it.
I feel it every day, sir.
And
I see it every day in my son's eyes. I mean, I can't tell him Dad's a lawyer, I feel it every day.
well, you understand where I'm coming from.
I
right?
understand completely where you're coming from, sir.
Okay. And, we want to see that. And not just from a gift.
No, I understand.
I have a question to, I guess, to the commission. If one comes back into the practice from where he is sitting, what has to be done? Fees, CLE, just go through what's...
Our position is that the sanction should be disbarment, in which case it would be a period of 5 years before Mr. Isassi could come back and apply again. The standards he would need to meet at that time are set out in the rules of disciplinary procedure under Part 11. If the board exercised discretion, hypothetically, if Mr. Isassi is given a suspension, under Rule 8.06, suspension is to run for the period of time originally assessed. So as I understand it, in this case, it would be 4 years.
What about the reduction?
As I understand the rules, the reduction doesn't matter. It's as if any attorney, there are two aspects of their life. There's the aspect where they're an ordinary citizen. Clemency can help a convict restore the rights of an ordinary citizen. But that other aspect, the license we carry, that's governed by a whole different regulator, the Texas Supreme Court. And the way our rules are written, it doesn't matter that there was a reduction. It doesn't matter that there was clemency.
Let me ask you,
It's 4 years from what date,
yeah,
though?
that's what I'd like to know is it was originally 4 years probation, and then it was reduced to 1 year, isn't that correct?
In the amended judgment, that's
Right, and if it was 4 years, what would that take you to in terms of a suspension?
I think in the commission's view, it would be the full period of suspension. So it would begin from the time Mr. Isassi actually agreed with the bar that he would be suspended.
Or you would think it'd be 4 years from, say,
Now?
today? Is that what your position is?
We could possibly go back to the date that he agreed to this suspension when there was a continuance of the BODA hearing.
On the other hand, if it's the 1 year, when would that end? I think my calculation is September, but I could be wrong, of this year. Mr. West, can you help us out on this?
Well, Your Honor.
I'm sorry, I want to test another question with Mr. Schaefer. Pardon my interruption.
Certainly, Mr. McKenna, go ahead.
I'm reading 8.06. I understand that your view is 8.06 should not be applied. But if it is applied, did I hear you say the 4 years starts from now, or would the suspension be limited to the period of the term of probation?
The sentence I'm relying on is the very final sentence of paragraph 8.06.
Yeah, so but I thought I heard you say you'd start the 4 years now rather than in 2015.
Sir, I think that's a possibility. I think it
Help
may
me
be.
understand what the basis would be for thinking it could begin today or back at the date of the agreed continuance. Why could it start that late instead of 2015?
Because that is the beginning of an actual suspension. The date of the agreed suspension, although Mr. Isassi may have been sitting home, not acting like a lawyer, in terms of his relationship with the bar, there was no suspension until the time of that
I'm
agreed
with
order.
you, I'm with you. But that, in reciprocal cases, somebody has been suspended 2 years somewhere, and in Texas, it's 2 years from the hearing. But under Rule 806, don't we have to give meaning to the phrase in the first sentence, quote, during the term of probation, close quote, and in the last sentence that you referred to, quote, until the entire probationary period as originally assessed has expired, close quote. How could it, what's the theory where it would start today rather than 2015?
I actually feel more sound talking about, not today, but the day that the agreed suspension went
So,
into effect.
which is in 2016. The agreed suspension was
July 26th.
July 29th, July 27th, 2016. But why not, how does that square with the language in 806?
Again, the language talks about early termination of probation does not result in reinstatement until the entire probationary period as originally assessed has expired.
Which would be September 30th, 2019.
That is certainly one view.
But tell me your view why it would be till 2020.
The other view has to do with what's the point of suspension. It's the period of time that the lawyer has a relationship with the bar where that lawyer's officially not practicing. So the focus there is the 4 years. The full 4 years, that there has to be 4 years for a suspension. Not necessarily tied to the date of the original conviction, but a full 4 years relationship with the bar where that lawyer's not practicing.
As in the reciprocity cases. But
As I understand it, reciprocity is a little different.
But you would write 806 differently than it's written, I suppose.
You might lodge an objection to that question as needed.
not sure how to answer that. But I do think that the reciprocity cases are somewhat different, clearly different from the compulsories. Compulsory, it's a Texas crime.
I'd like to hear from Mr. West on the topic that's being discussed.
Yeah, and most specifically, tell us in your view, what range of options we have. We know we can disbar. You don't need to talk about that.
I understand.
What
I don't want you to talk about that either.
I understand it, but what are the ranges from the low end up to disbarment, but not including disbarment, in your view?
In my view, because of both the Ament case and the Cuellar case that I've provided you, you all are familiar with the Ament case. And the Ament case specifically says the remedial purpose advanced in favor of compulsory discipline proceeding, the principal reasons for them exist. It says the remedial goal of protecting the public from criminally censured attorneys is fulfilled if suspension is limited to the period of probation. So we have to look at what that period of probation is. I believe in this case, one view the board could have is that it was 4 years reduced to 1 year. And under what Mr. Taylor mentioned is the proper application of 12.44A. And Mr. Taylor, I apologize to you if I misled the board. That was not my intention in asking or him answering the question the way we did. You cleared it up, and thank you for that. But I think there's one other issue, and that's the application then of Ament to this particular fact situation because of Chapter 42 that led to this particular conviction being set aside. And that's what the Cuellar case speaks to about what a set aside of a conviction is. And we believe under Ament then that the board would be remiss to grant a period of suspension longer than the termination of that conviction on September 30th of 2016. And if you combine all of the days that my client has served, he has served in an amount in addition to all the time that he should have been suspended. So that's why we believe the correct action of this board would be to dismiss this.
So you do not agree that it would be, or that we could possibly find that it's 4 years from September 2015? You think that's a wrong application of the rules?
And I do, and I think I'd like to offer you some case law of the application of Ament to a situation like this. I don't think we have any case law. But I think that between the two options are really to apply Ament to what happened in this case, and that is we had Mr. Isassi's conviction set aside by the Chapter 42 proceeding. Either do that or select a 1 year probation. I think those are the options, and I would argue strongly, of course, in favor of the Ament application.
I want to ask what is almost the same question Mr. Kittner did and Ms. Kinzer did, but I want to hear a little more crisply this.
I'll try.
I appreciate the excellent work you're doing. I'm picturing 4 potential outcomes that BODA might consider in its discretion. 3 of them under 806, 1 of them under 805.
Correct.
And I want to learn from you if you think that there are 4 or that there are only 2 or some other number. So we're all agreed 805 is one eligible
Certainly.
focus. As to 806,
Only 2.
so I want to hear the 2 that you think are proper for BODA to consider as opposed to the 3 that I've just mentioned.
I think that the proper one among the 2.
Not which one you advocate, but what is in the realm of legitimate consideration to exercise
Legitimate
discretion.
consideration, you know which one I advocate.
Of course you do.
The legitimate consideration would be 1 year of suspension to comply with the reduced probation of 1 year.
From what date?
That would be it would relate back to the date of the conviction, that 1-year
Okay,
probation.
well, and again, I don't mean to step on Mr. McKetta, but under that theory, there's nothing to serve because the 1 year has expired.
Correct.
And so is it no suspension at all on the one hand, or disbarment on the other hand, and nothing in between?
Unfortunately, I think that's where you are. Yes,
Those are the two choices we have.
Wow.
Yes, sir.
So you do not think an available consideration is September 30, 2017,
No, I don't.
September 13,
Are you
30,
saying-
2019?
Pardon me?
You do, under the original judgment, September 30, 2019
That would
would
be,
have then been an eligible consideration, and in your view, that is not available
I
for
agree.
our consideration.
I don't think it is.
And that's solely because he got it reduced from 4 years to 1
Correct.
year.
Under the
It's
amended
2
judgment-
years. It's 2 years probation. He got it reduced to, not 1 year. It's
no,
1 year
there was an
probated
order.
for 2.
Mr. Taylor, let me finish and see if this doesn't address that as well.
Okay.
So, September 30, 2019, you think is not an eligible punishment for our discretion to consider?
I've said that, yes, sir.
Under the 2-year amended judgment, September 30, 2017, back then, you would agree would have been an eligible consideration.
Yes.
Today, is it an eligible consideration?
I suppose it would be an eligible consideration. I think again, it's not the one I'm advocating. I think
And
it's
then the one you're advocating is that based on the order terminating probation, September 30, 2016 would be the outside date other than the agreed continuance suspension.
I believe that because of the order that didn't only terminate probation, but terminated his conviction, set it aside.
Do you take the view that the judicial decision, either in the amended judgment in April 2016 or on the September 30th order 2016, do you take the view that those two judicial decisions prevent us from exercising a different discretion than those?
I do, under AMET, I do, yes.
Okay, now my question is, have you an evidentiary record where we can see whether those judges in April 2016 or September 30th, 2016 had available to them at the time evidence of the factors that are incumbent on this board to consider? Do you have an evidentiary record from either of those hearings?
I think so, and I think it was good of the commission to add to this record P13 that
Had no
provides.
exhibits or testimony, did it?
Pardon
It
me?
had no exhibits or testimony.
There were no exhibits or testimony. All we had was the transcript of the hearing, but you have the judge weighing these issues as he was considering whether to set aside this judgment. I think that is some evidence.
Well, no. Where did the exhibit P13 show us that the judge was or was not apprised of the 2016 4-month probated suspension? How do we know whether
Well,
the
it
judge
would be a
had
public
that?
record, Mr. McKetta,
Well, how
and
do
he
we-
has to we have to presume that he has knowledge of the public record. Not only that, it's a small community, and it was not a private reprimand, it was a public sanction. So we have to, I don't agree with you that you have to have an evidentiary record of that public sanction that was well-known in the community and was a public matter with the bar. I think
I
he
agree.
well knew it.
I agree he does not need his evidentiary record, but you took the view that this board was not permitted to exercise different discretion. If we have different evidence in front of us, aren't we required to consider that evidence under the appropriate factors?
Mr. McKetta, your argument reminds me of AMET so well because I remember it and how we argue back and forth about that very issue.
From
And
Ms. McKeeman and Mr. Watkins on the other side of it.
I can't disclose what our deliberations were. I'm still required to maintain that confidentiality. But I know the board went in one direction and the Supreme Court told us something different. And so I guess I'm going to stay on the Supreme Court side on this one. Thank you.
Couple of quick questions.
Yes, go ahead.
if I may. Mr. Isassi, what law school did you attend?
I went to Texas Southern University in Houston.
In the trial that ended in the conviction in 2015 in Clayburgh County, did either your counsel or the state attorney file a motion transfer venue? Thank you, sir.
Any other questions, Mr. Gonzalez?
Let me follow up a couple. One of the other factors is the compliance with terms and conditions of probation. And in reviewing response exhibit number 7, you've tendered some community service, and what I'm asking is, are the 67 hours or so of the Cub Scout pack meetings, are those the same troop or pack that you have attended with your son?
Yes, sir.
And so those were presented to the court as compliance of community service?
Correct.
And likewise, on the volunteer service for Santa Gertrudis IST, are those the school where your child is attending?
He is.
Okay. So the parts where you were talking about being a father and as a Mr. Mom, you were getting credit for that as well by turning this into the court for community service?
Yes, sir. He allowed me to do stuff in the community, but I also did pick up trash with the probation department as regular probationers, and I did other things besides the stuff with my child.
Mr. West, just one follow-up. I want to make sure it was stated by Mr. Schaefer that, and I think correctly so, that until he agreed to the suspension with the board here, that he wasn't under any suspension. Is that correct?
Let me make sure I understand you.
In other words, he could have practiced. I know he didn't.
He didn't. He did it himself.
Okay. So just help me out from your math. If we take the date that he was first suspended, actually suspended by us, and that was as a condition.
July 26th,
Right.
2016.
I think that's right. And wasn't that as a result of?
277 days.
And that was, in order to, part of that was getting a continuance, wasn't it, as I recall?
There was a continuance, and then we had the problem with the court reporter last
Right.
time.
That was in
and then-
January.
Yes, sir. So it's a total of 277 days.
So as of today, as we sit here, not the imposed suspension pursuant to some order is
Well,
200.
He would have 277 days, and then he had that period of, the suspension, 120 days.
Fully probated.
Pardon me?
It was fully probated.
Yes, sir. I was talking about the suspension that he actually served, though, for 4 months.
That order says fully probated, does it not?
I
He said he
believe-
complied with with the suspension, but in fact, it was fully probated.
I don't recall. But if it was, we wouldn't count those days, but I had them counted as 120 days that he was suspended during that time. So that'd be 277 plus 120. But if it's only 277, I stand corrected.
Then he would have 365 minus 277 to serve?
Yes.
Which
Correct.
I think would take us into September of this year.
Yes.
So it would not be an immediate dismissal under your view, if that's correct.
If that was what the board wanted to do.
Any more questions for this witness? Maybe.
No, I don't.
Maybe excused? Okay, thank you. Anything further, Mr. West?
No, Your Honor.
Mr. Schaefer, do you have anything else you want to offer?
A brief closing.
Absolutely. Let's take no more than 10 minutes because I know some people have some obligations they need to get to, so.
We know from the Caballero case that in a compulsory discipline matter, the starting point is disbarment. There needs to be something that carries the case to an area of discretion. And we know from Duncan and Philpott that the board is to consider the nature of the crime, the elements of the crime. And the particular crime that triggered compulsory has been discussed by the Texas Court of Criminal Appeals. This is the Vasilas case, 187 Southwest 3rd, 486 at 492. And there, the court stated that section 37.10, that's the tampering statute, the legislature intended to prevent a multitude of harms, including perpetuation of fraud upon the court and miscarriage of justice that would result from the use of falsified records. The kind of crime at issue, if we even do get to Filipov, it is the kind of crime that affects the lawyer's practice. There are some credibility issues that come up. So I think even if we get to a place of discretion, that the balance of considerations still remains solidly on the side of disbarment. Important issue, even though we're in a situation where Mr. Isassi was able to get a judicial clemency order, clemency might restore those rights. Mr. Isassi talked about rights, but our license is a privilege. The Heard case, back to the 80s, the Supreme Court talked about that. The law license, it's not a right, it's a privilege. And looking at the plain language of the clemency statute, it doesn't say anything about restoring privileges. It talks about restoring rights. And we have precedent in the Goldberg case where a similar argument was made. Lawyer took the position that once he got clemency, I think the term was that the law license was automatically revived. And there was no jurisdiction, no authority, and the court had no problem knocking out that argument. Just in closing, I mentioned the thing about discipline. Words are important to all of us. And I know that our immediate task is to look at what is safe for the public, what is safe for the bar, and even what is safe for the lawyer who's here. But when we're done with this case, and there's a written opinion, what do people learn about it? After we've all left and gone on to do other things, what do they learn when they look at this authority? And if it's something other than disbarment, I think what we'd be telling the public and lawyers who come behind us is that if you're county attorney and you commit an intentional crime, small I, I'm not talking about capital I, but if you commit an intentional crime, it's okay. You can always be a judge. And then we go on and would learn from this case that if as a judge you commit a state jail felony, intentional crime, this time capital I, it's okay because you can always go back to practicing law. And that's not something we want folks to think about when we're trying to teach. We're trying to learn, help people learn through this disciplinary process. So the commission asks that disbarment be sanctioned.
Thank you. Mr. West?
These aren't my words of argument. These are our Supreme Court, who said retribution and deterrence are not the principal reasons for which compulsory discipline exists. And I know it's hard for the commission in the role that they have and CDC attorneys in carrying out that obligation and responsibility to remember that those two things, retribution and deterrence, are the things they shouldn't have their eye on. And that's what I just heard Mr. Schaefer tell you. The remedial goal can be achieved and accomplished in other ways. this is a broken man that you heard from today. He isn't hiding. He brought his family here in order to be able to witness to you all in front of them the wrongs that he has committed and accepted responsibility for. His community is aware of it. None of us want to walk in those shoes, I can guarantee you. It's easy to sit here and inspect him like a bug under a microscope. But, you know, he's a real person. He's someone who's made a mistake, and he's owned up to that mistake. But we did have some people that looked at him pretty closely. Some people who knew him. Some people who he appeared before. Some people who he worked with and played with and worshiped with. And those people looked at him and said, he's worthy of getting another chance. Let me remind you that judge who granted that claim, it wasn't just he got clemency. He had to go before that judge, and that judge says, I'll state, I think he has shown, based on probation, he's done a good job. I think he's back. I think that he will not commit another stupid mistake like this again, or any type of mistake that involves any type of illegality, and I think he deserves a chance. That's my opinion, so I'm going to grant it. Ladies and gentlemen, that's what I think you should do. Your job's hard. I've done this. It's hard. I think it made me a better lawyer through the years doing what you do. Because you look at these hard issues very personally, very fundamentally. But I think I have brought you today in a client who is more than a client. He's a man who has had some very difficult things happen in his life that he caused happen. And he has accepted responsibility for that. And he's asking you, like the judge in his community who knew him, to give him that other chance. Thank you.
Thank you.
Chair, just brief, I want to make sure that our original exhibits are admitted. We've been
Yes,
pretty-
all the exhibits are admitted that you had agreed upon. There were no other exhibits, as I recall, so we have them all. They were all admitted. I thank you for your time. We will take it under advisement and let you know. Thank you very much.
Thank you very much.